All right, court is calling 2021 CR 7498, State of Texas versus Jacqueline C. Sanchez. Can I have parties announced for the record for the state?
Daniel Escobar for the State of Texas.
Defense?
Karen Corby for Jacqueline Sanchez, defendant, Your Honor.
Are you Ms. Sanchez?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Jacqueline C. Sanchez who was placed on deferred adjudication in 2021 CR 7498 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on December 10th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2. On or about the 12th day of February 2024 in Bexar County, Texas, the defendant, Jacqueline C. Sanchez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
Your Honor, state we resolve the violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation?
The moment Jacqueline says she's guilty, you can feel the heaviness in the room. She knows exactly what's at stake, possibly up to 20 years behind bars. And yet, she still chooses to admit the truth. This isn't just about the law anymore. It's about doing whatever she can to move forward and survive.
All right, you're whispering.
Yes, ma'am.
All right. Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, it's for 2 years TDC.
That is our proposed agreement, Your Honor.
All right, why should I give her the minimum? What has she done on probation?
Judge, I can tell you that she did complete drug court. Unfortunately, she kind of fell short in the reentry court. She had tons and tons of negative UAs. She had been working really, really hard. I believe that the underlying offense was 7 grams, so I know it's 4,200, but it was closer to the 4 than it was 200. And so she does have, I think, 139 days in jail. She just really just wants to put this behind her and move on with her life. She tells me she's been working for 2 years at the Tower of Americas. She's hoping they'll keep her job open for her, depending upon how, if you follow the recommendation, how long it takes for her to.
Her lawyer is doing everything possible to show she's turned her life around. Steady job, supportive family, completed drug court. She's clearly trying. But things change quickly in court. Because even when someone puts in the work, especially with addiction in the mix, it doesn't always lead to a second chance.
Got a house that she bought. Her kids are living in it. They've been paying the rent. She's hoping that will sustain itself while she's gone. But Judge just wants to put this behind her and move on. But she did do a significant amount of work on this probation.
All right, do you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Jacqueline C. Sanchez.
All right, why didn't you do well in drug court?
I'm sorry, what was that again?
Why did you not do well in felony drug court?
I didn't have the money to pay for the UAs, ma'am.
No. Felony drug court usually will not remove you from their program because you can't pay UAs. Are you telling the court that you were removed from felony drug court because you couldn't pay for the UA?
And I had a relapse. I had drank 4 beers, ma'am. She actually graduated from drug court, I believe, and then she went to the reentry. So I think she completed drug court. So I don't think she had a problem doing drug court. I think it's when she got out.
So here's my question. Why did they remove you from their reentry program?
Because I drank 4 beers, ma'am, on the 23rd.
No, usually it's more than that because felony drug court usually understands relapses. Am I wrong in that? Do they not understand that you had a relapse?
They usually do, ma'am, but this time they felt like I played them.
This moment really struck a chord. She admitted to drinking 4 beers, a relapse. But what truly shattered things wasn't just the slip. It was the court feeling misled. One line said it all. They thought I was lying. That's the difference between getting another chance and serving 6 years. In court, trust is everything, and once it's gone, it's hard to get back.
I was lying. I lied to them.
Okay. All right. Probation.
Judge, the note that was received from drug court was.
Well, just one second. Any objections to probation giving me some insight in whether or not I should follow this agreement?
Okay.
And also, they found on my phone that I was trying to get, methadone for a friend because he relapsed and he was trying to get clean, and that's what I was doing. And I had somebody else ask me, I was looking for marijuana for somebody.
Wait a minute, what?
I was looking for marijuana for somebody. They asked me to look for it. They text me if I could find it, and I told them yeah, but I never got to doing that.
Oh, so now we're getting to the point. So you were in felony drug court in the reentry program, and you were looking for drugs for other people.
Which I think she was looking for methadone and possibly marijuana. She's not, the perfect probationer, but that's what she told me, Judge. I don't think it was.
I made a mistake, Judge. I'm sorry about that.
Nope, you made choices.
She said she was just trying to help a friend find methadone. That part the court could understand. But then came the messages about looking for marijuana, even if she never went through with it. Those texts changed everything. To the judge, it wasn't just someone trying to stay clean anymore. It looked like she was slipping back into that world, even if it was for someone else.
All right, is there anything else?
Judge, again, we just ask that you consider the fact that she did spend a lot of time in drug court. She has been straightforward with you, I believe. And ask you to follow the state's recommendation of 2 years TDC.
All right, and do you want me to hear from probation or no, counsel?
Sure.
No.
I don't think my client's trying to hide anything, Judge.
Okay. Probation?
The information that was received from felony drug court was she did finish the program successfully. However, during the aftercare portion, there were UA tests with positive ETG results, and a phone search was conducted and text messages revealed that he was communicating with negative contacts and negotiating the sale of illegal drugs.
Okay.
I did reach out to felony drug court.
There was no salvaging the 2-year deal. The judge's tone turned firm. These aren't mistakes, these are choices. That line hit hard. She wasn't quietly struggling. She was openly texting about drugs while supposed to be rebuilding her life. And that's what shut the door.
All right, so this is what the court is going to do. As previously stated, the court is finding violation of condition number 6 true.
So I think it's
I'm sorry, number 2 true.
Yes.
Thank you. The violation of condition number 2, the court is finding that to be true. There's a $1,000 fine. Time and money were run concurrent. Was the $57 ever paid for the laboratory testing? Do you know if you ever paid that?
Drug court?
Ah.
Okay.
Okay.
No. I haven't taken it.
Okay. There should be $57 restitution to SAPD for laboratory testing. If you would like, I could have you referred to the therapeutic community. It doesn't increase your time at the prison. It's just something to hopefully help you maintain your sobriety.
Okay, I'll take that.
All right, therapeutic community. Court's going to sentence you to 6 years.
She agrees to do rehab while in prison, but it's clear from her expression, this isn't what she hoped for. This wasn't the plan. Still, it's a consequence she can't avoid anymore. At this point, there's no more room to push back.
I'll give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you review that with your attorney? Did you understand it? All right, did you review that document with your attorney? Did you understand it?
I'm just leaving it to me right now.
Okay.
I explained to you. So you have one of the documents. You understand?
All right. Did you review that document with your attorney? Did you understand it?
Yes.
All right. Because this is not, I did not follow your proposed agreement with regards to sentencing. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Good luck to you. Even though you're going to the prison, if you get out of prison and you need help, you feel as though that's not being addressed, so you don't know who to contact, felony drug court is always available, okay?
Thank you.
Okay, thank you. Good luck to you.
The judge didn't have to say anything more, but she did. She looked at Jacqueline and said, "If you ever need help again, we're still here." That kind of compassion is rare, especially right after giving someone 6 years. But in that moment, those words felt like a small ray of hope breaking through a very heavy day.